All right, you all may be seated. Welcome back, ladies and gentlemen. Thank you again for being on time. You have always, this entire time, you have really been on time, and I appreciate it. We are now ready to do closing arguments. This is the State of Georgia versus Edrick Faust, SU 24 CR 0547. Is the state ready for closing arguments?
Yes, Your Honor.
Is the defense ready for closing arguments?
Yes, ma'am.
All right, thank you. Ladies and gentlemen, I want to tell you a few things. The first is kind of our timing. We are going to hear closing arguments, and then the court, of course, charges the jury, as I mentioned to you all earlier. I'm going to then have you go into the jury room and elect a foreperson. I'm going to then ask the foreperson to discuss with all of you whether you want to deliberate tonight, starting tonight, or whether you want to go home for the weekend and come back on Monday and begin your deliberations. So I'm going to give you that choice. So I just want to let you know sort of the plan. We are doing closing arguments now, ladies and gentlemen, and I want to also tell you, as I told you at the beginning of the trial, that any statements made by the attorneys are not to be considered as evidence. Mr. Yalamanchili.
Thank you, Your Honor. Court bears with me for just a moment. I'm going to reposition the podium. On January 19th of 2021, Tara Baker was taken out of this world. Her life extinguished by the defendant in this case, Edrick Faust. Mr. Faust entered Tara's home and caught her as she was going through her morning routine. He stabbed her, brutally bashed her head, and strangled her as he forcibly raped her, sodomized her orally, and sodomized her anally. When she was discovered by firefighters and police, her hair still smelled like shampoo. Ladies and gentlemen, you've heard the evidence in this case for 2 weeks and went through about a week of jury selection before that. And we're here at the closing argument after a family has waited 25 years for justice for their daughter. And it's time for you to write the last chapter of this story. The state, in closing argument, is afforded the opportunity to go both first and last in the summation. The reason for that is that we bear the burden of proof in this case. And that burden is guilt beyond a reasonable doubt. It's a burden that I accept readily. The burden never shifts. The defendant is not required to present any evidence ever. And it's a burden that I accept readily on behalf of the state of Georgia because it is a burden that we meet by bringing you the truth, the facts, and the evidence in the case. Not conjecture, not unsupported speculation, not statements about the evidence that end up being false after you actually hear it, but the truth and the facts of this particular case. You have a 12-count indictment that you will consider. And during this initial portion of our closing argument, we are not intending to tell you the same things that we're going to tell you at the end. I respect your time. I'm going to try my best not to repeat myself. As it relates to count one is malice murder. And the law in this case will come from Judge Lott, and you should look to her jury charge in order to determine the law that applies to this case. But I expect that Judge Lott will instruct you that in count one, malice murder, it requires that the state prove that Mr. Faust did unlawfully and with malice aforethought on January 19th of 2001 caused the death of Tara Baker, a human being, by strangling her with a cord and stabbing her. And in count 2 through count 5, I believe Judge Lott will instruct you that Mr. Faust is charged with felony murder as it relates to the felony offenses of burglary, aggravated sodomy, and rape. And I believe that what she will instruct you as it relates to those offenses will come in the charge, and we will discuss that. After those offenses of burglary, aggravated sodomy, 2 counts, rape, as well as possession of a knife during the commission of a felony, you will receive further instructions. And one of those instructions that Judge Lott is going to give you is about what we just discussed, the issue of reasonable doubt. And I think what the judge will instruct you in part is a reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based on common sense and reason. And I know sometimes it can be difficult as a juror to understand how you should weigh the evidence, but I think that the end of that second sentence is maybe the most instructive as to what a juror's role is. And a juror's role is to seek out the truth in the evidence that is presented before you. Your job is not to seek out doubt, it is to seek out truth. And the truth in this case is that Mr. Faust is guilty of each of the offenses for which he is charged in the indictment. I think it's important when we discuss malice murder to talk about what is required of the state in order to prove that. The state does not have to prove premeditation. The state does not have to prove motive. Malice aforethought in the state of Georgia does not mean premeditation. The state has to prove that Mr. Faust caused the death of another person, Ms. Baker. He did so unlawfully, meaning without any type of justification, and he did so with malice aforethought. And malice as a term is used here is not necessarily ill will or hatred. It is rather an unlawful intent to kill. This, as I stated before, the state does not have to prove premeditation in order to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. The malice in this case is clear. I'm not going to display in front of you now those images from both the autopsy and the crime scene that you've been subjected to. I know that they are not pleasant images to look at, but if you are looking for evidence of malice in this case, the manner in which Ms. Baker's life was taken was all the evidence of malice that's necessary to support a conviction under the laws of the state of Georgia. I think that the judge is also going to instruct you on felony murder. And although she will give you an instruction at the end, I think it's worth bringing up for you as you consider the evidence as argued to you by the attorneys in these closing arguments. And I think what the judge is going to instruct you is that for felony murder, the state must prove that the defendant caused the death of another person by committing a felony. In causation, as it relates to felony murder, I'd expect the judge will instruct you that you may find the defendant guilty of felony murder if you believe that he or she caused the death of another person by committing the felony of, and in each count it will have the predicate felony or the underlying felony that's the basis for those felony murder counts. By committing the felony of whichever felony is the predicate, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. And so when we're talking about burglary as a predicate act for felony murder, what we're talking about is the commission of that burglary, the entry into the home in order to commit the sexual offenses that are relayed in the burglary being a substantial and necessary part of causing the death. The evidence in this case establishes that. It also establishes the predicate felony of aggravated sodomy being, again, a substantial and necessary part in causing the death in this case. It also establishes the evidence in the case that the rape and then the aggravated assault of strangulation and stabbing Miss Baker as predicate acts of the felony murder also played a substantial step in causing her, substantial and necessary part in causing her death. So that's what felony murder means. It means committing a felony that plays a substantial and necessary part in causing the death of Miss Baker in this case. I know that's not something that jurors typically know of necessarily as it relates to the way that the law is applied to those circumstances, so I felt like it was important to go over those things with you. The possession of a knife during commission of a felony, I think the arson in the first degree is pretty clearly self-explanatory. It's clearly from when Mr. Faust takes the blanket out of the living room, lights it on fire, and goes to start the fire in Miss Baker's bedroom. Possession of a knife during commission of a felony. Obviously, the knife used in this matter is longer than 3 inches in length. I think that's been clearly established by the evidence in the case. And then that knife was used in a felony involving another person, that being Miss Baker's murder as alleged in the indictment. So as you're listening to the evidence, those are the things that you are listening for. As it relates to the rape charge, that is carnal knowledge, meaning that Mr. Faust penetrated Miss Baker's vagina with his penis forcibly and against her will. The evidence of force and against her will is very clear from the images from the crime scene. As it relates to the offense of aggravated assault in count 5, I think that the aggravated assault being the strangulation with a cord and the stabbing. As it relates to the 2 counts of aggravated sodomy, one is for the oral sodomy, forcibly and against her will, that was performed by Mr. Faust on Miss Baker, and then the other one is the anal sodomy, forcibly and against her will, performed by Mr. Faust on Miss Baker. Ladies and gentlemen, the next thing that I want to talk to you about is what is evidence and what is not evidence. Evidence is what you hear from the witness stand and the exhibits that are emitted, the videos that were played for you, and the things that will go back with you into the jury room. What I say is not evidence, whether it was in opening statements, whether it was in questions that I asked witnesses, or anything else that I've said to you. This closing argument is not evidence. It is my argument to you about what the evidence shows. The same thing goes for the defense in this case. Nothing that Mr. Cruz says is evidence. No questions that Mr. Cruz asked are evidence. When there is a conflict between what you've heard on the witness stand and what it is that Mr. Cruz says or what I say, remember, what we say is not evidence. So when Mr. Cruz says to you that the hairs that were found in Miss Baker's hands were going to be proven to be Mr. Melton's hairs, that...
Excuse me. May I see counsel at the bench, please?
Ladies and gentlemen, you may remain.
Another outburst like that, those of you who have made the outburst are going to be asked to leave and you will not be able to return. I don't know if everyone who made a comment heard me say this when I first got started, but this is a, well, I'll just leave it at that. If there are any other comments like that by anyone in the audience, I'm going to stop the proceedings. You will be escorted out by the deputy, and you will not be able to return. And that goes for everybody that's in the audience. And I hope that I've made myself clear about that. Thank you very much. All right, your objection is?
Cruz demonstrated to you about Miss Baker fighting off her assailant while his hands were around her throat, clawing at his hands and then reaching up and ripping his hair out, remember what the evidence actually was. The evidence that actually came from the hair analysis told you that the hairs in Miss Baker's hands were her own hairs. Okay, so remember that when we're talking about what the attorneys say versus what the evidence is. When things have been said or claimed that were not supported by testimony from the witness stand, whatever they may be, those are not facts for you to consider because they are not facts that are established by any evidence in the case. I want you to pay close attention to Mr. Cruz as he makes his closing argument to you. And when he gets done, I'll come back to talk to you about the actual facts and evidence in this case that prove beyond a reasonable doubt that the defendant, Mr. Edrick Faust, is guilty of each and every offense in this indictment.